Hey guys, welcome back to this particular channel. Let's crack AP and TS Lawcet examination. So this is a dedicated channel for TS and AP Lawcet preparation. So if you're somebody who is preparing for TS and AP Lawcet exam, please subscribe to this particular channel and click on the bell icon so that you will not miss out on any notification whenever a live class is happening over here. So if you guys can hear my voice and look at the presentation on the screen, and if my video is clear, please give me a very quick yes in the chat window so that I will proceed with today's class. Right. So today we are going to talk about, we are going to discuss certain important previous year questions from the Lawcet examination. In yesterday's session, I talked about the importance of previous year question papers, for your Lawcet preparation. So today we are going to solve some of the legal aptitude questions, from the TS Lawcet 2022 question paper, the most recent question paper, I would say. Okay, so here I have, I took shift 1 question paper of 2022. So this is 2022 shift 1 paper. So today we are going to solve all the one-liner questions, which means the direct questions, direct on questions మనం solve చేద్దాం. And passage based we will do it in a different session. Hi, yeah, very good, Madhuri. Next, let us proceed with the first question. Which of the following words has not been written in the preamble of Indian Constitution? భారత రాజ్యాంగ ప్రవేశికలో ఈ క్రింది పదాలలో ఏది రాయబడలేదు? Sovereign, socialist, democratic, and Bharat. What do you think is the right answer? Please write it down in the chat window very quickly. I want very quick answers. So preamble. In the preamble says, we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular and democratic republic. But nowhere in the preamble the word Bharat is used. So preamble మొత్తం అంటే భారత రాజ్యాంగ ప్రవేశికలో ఎక్కడ కూడా భారత్ అనే వర్డ్ ని యూజ్ చేయలేదు. So that is why Bharat is the right answer. It has not been used. ఏ వర్డ్ ని యూజ్ చేయలేదు అని అడిగాడు. So that is what is answer. Very good, Nayak. Excellent. Next answer. Okay. Very good, Ramesh. Which of the following is not a fundamental duty? Uma, that is sovereign, is already used, Uma. So, republic, first adjective is sovereign. So, please go and refer preamble. So, a word is already used, Jason. So, Bharat is the right answer. Which of the following is not a fundamental duty? అంటే క్రింది వాటిలో ఏది ఫండమెంటల్ డ్యూటీ ప్రాథమిక విధి కాదు? ఓకే, 1 ఈజ్ సేఫ్ గార్డింగ్ పబ్లిక్ ప్రాపర్టీ అంటే ప్రజా ఆస్తులను రక్షించడం. నెంబర్ 2 ఈజ్ ప్రొటెక్టింగ్ ద సావరెనిటీ, ఇంటెగ్రిటీ అండ్ యూనిటీ ఆఫ్ ఇండియా అంటే భారతదేశ సార్వభౌమాధికారం, సమగ్రత మరియు ఐక్యతను రక్షించడం. డెవలపింగ్ సైంటిఫిక్ టెంపర్ అండ్ హ్యూమనిజం శాస్త్రీయ దృక్పథం మరియు మానవతావాదాన్ని అభివృద్ధి చేయడం. అండ్ 4th one is protecting religious rights, which is not a fundamental duty. Which is not a fundamental duty? Protecting religious rights. అంటే మతపరమైన హక్కులను రక్షించడం ఫండమెంటల్ డ్యూటీ అంటే ప్రాథమిక విధి కాదు. వెరీ గుడ్ నాయక్, దట్ ఈస్ ద రైట్ ఆన్సర్. వెరస్ సేఫ్ గార్డింగ్ పబ్లిక్ ప్రాపర్టీ అంటే పబ్లిక్ ప్రాపర్టీ కెన్ ఇంక్లూడ్ రోడ్స్, ఇట్ ఇంక్లూడ్స్ బస్సెస్, ట్రైన్స్ అండ్ ఎవ్రీథింగ్. సో ఆల్ ఆఫ్ దీస్ safeguarding public property is a fundamental duty under Article 51I. 51 capital A I. Right. Next thing is protecting the sovereignty. Very good, guys. Very good. Uma, very good. 4 is the right answer. So under 51AH, okay, protecting the sovereignty, integrity, and unity of India is a fundamental right. And development of scientific temper, humanism, and a spirit of reform. Very good, guys. Excellent. Is a fundamental right under Article 51AH. So sovereignty and all comes in the first, right? So sorry, this is C. 51AC is protecting the sovereignty, integrity, and unity of India. 51AI is safeguarding public property and abjuring violence and violence jarakunda chudam. And development of scientific temper is in 51AH. So H is 8, right? Yeah, this is the right answer. Sorry, protecting of religious side is the right answer, but AH is the correct one over here. Next one. Writ petitions before the Supreme Court under Article 32 are subject to the rule of res judicata ఎక్సెప్ట్ ఇన్ ద కేస్ ఆఫ్ అంటే ఆర్టికల్ 32 ప్రకారం సుప్రీంకోర్టు ముందు దాఖలు చేసిన రిట్ పిటిషన్లు ఈ క్రింది రిట్ పిటిషన్ విషయంలో తప్ప రెస్ జుడికేటా నియమానికి లోబడి ఉంటాయి. సో ఫస్ట్ థింగ్ you have to understand what is the meaning of res judicata. When I was talking about legal maxims, I discussed about this particular term res judicata. What is the meaning of res judicata? Please write it down in the chat window. No, Uma, that is the wrong answer. First answer me what is res judicata. Res judicata ante, so res judicata ante a case that is already decided. Okay, a case that is already decided by the court. What do I mean by already decided? Already decided ante just subordinate court lo decide అయినట్టు కాదు. It has to be decided in the subordinate court. In the high court also the appeal should be done, and in the supreme court also the case has to be disposed of, right? So in the highest court వరకు వెళ్ళిన తర్వాత court case completely dispose of అయిన తర్వాత we call it as the case is res judicata and the issue is resolved already. Okay, when there is res judicata you cannot approach the court again. So when a case becomes res judicata, then you cannot, which is already judged. So you cannot go to the court again. But when it comes to the writ of habeas corpus, to apply, to file a habeas corpus writ petition, you can actually file even if the case is already decided. What is the meaning of habeas corpus? Okay, so habeas corpus is to have the body or to present the body. Like for example, if you are arrested, let us say I am arrested here in New Nallakunta, Hyderabad. So if I am arrested within 24 hours, excluding the travel time, so travel time is తీసేసి remaining 24 hours లో I have to be submitted before the magistrate by the police. ఒకవేళ నన్ను వాళ్ళు సబ్మిట్ చేయకపోతే before the magistrate, then my family members or somebody who is related to me can file a habeas corpus writ petition in the court. So habeas corpus writ petition file cheyadaniki whether the case is already decided or not doesn't matter. Okay, but in other cases to issue the writ of quo warranto. So quo warranto is by what authority? To issue a writ of certiorari. So certiorari is generally quashing the order of a lower court by a higher court. So ఒక పెద్ద కోర్ట్ చిన్న కోర్ట్ ఇచ్చినటువంటి ఆర్డర్ని క్వాష్ చేయడం, that is certiorari. And prohibition is completely prohibiting something. So in all of these cases, if case is already decided, you cannot go and file a case. But for habeas corpus, you can go and file a case. Is this clear? అర్థమైందా ఈ టాపిక్? Did you understand? There is an exception in res judicata for the writ of habeas corpus. Next question. Yeah, very important. Again, you have to read the question carefully, right? Question jagrata chalo. Question emarthunde, which of the following has not been laid under Article 19 of the Indian Constitution. Article 19 లో లేనటువంటి ప్రావిజన్ ఏంటి రాజ్యాంగంలో? ఆర్టికల్ 19 నెంబర్ 1 ఫ్రీడమ్ ఆఫ్ స్పీచ్ అండ్ ఎక్స్ప్రెషన్ అంటే వాక్ మరియు భావ ప్రకటన స్వేచ్ఛ. నెంబర్ 2 ఫ్రీడమ్ ఆఫ్ అసోసియేషన్ and association స్వేచ్ఛ, it is given something like that. Next, freedom of assembly. So assembly is to gather, not the assembly that you think about. And then freedom of minorities to establish or to open their educational institutions. So which of the following is not laid? So the answer is freedom of minorities to open their educational institutions. E right undi, this is a fundamental right, but this is there under which article? This is there under which article? It is there under Article 30. Very good Madhavi, very good Ramesh. So Article 30 లో freedom of minorities కు ఒక రైట్ ఉంది to establish education institutions and administer them. So but ఈ రిమైనింగ్ రైట్స్ అనేవి అవి ఆల్రెడీ ఆర్టికల్ 19 లో ఉన్నాయి. Like for example, freedom of speech and expression, freedom of association. Okay, so association and freedom to assemble. So assemble doesn't mean anyone and everyone can go. So you have to assemble without arms and ఎటువంటి weapons లేకుండా you can assemble. Okay, and you also have freedom of movement, and ఇండియాలో you can go at any place. So ఇండియాలో మీరు ఏ ప్లేస్కి వెళ్ళాలనుకో వెళ్ళొచ్చు. There are certain restrictions also on freedom of movement. You know, to get into certain northeastern states there are certain exceptions always, but that's a different thing altogether. You have the freedom of movement, and you also have the freedom of residence. So it means you can stay at any part in India. Again, there are certain exceptions to that particular thing. And you also have the freedom of profession. You can choose whichever the profession you want. You want to do a business, you can do. You want to work in some company, you can work. So all of these things are there. Okay, so 6 rights are guaranteed under Article 19: freedom of speech and expression, freedom of association, freedom of assembly, freedom of movement. Remaining 3 I'm writing over here. And then, sorry, I think my board, okay, let me just write over here: freedom of movement, residence, and profession. Right. I hope this is also clear. Next, question number 65, which is the fifth question technically. A factual question, I would say, nothing much of a concept. In the context of our constitution, the date of 9th December 1946 is known for which of the following? మన రాజ్యాంగం దృష్ట్యా 9 డిసెంబర్ 1946 తేదీ క్రింది వాటిలో దేనికి సంబంధించింది? What do you think is the answer, guys? So this was the date when the first meeting of Constituent Assembly was held. So Constituent Assembly first అంటే 9th December 1946 రోజు వాళ్ళు ఫస్ట్ టైం కూర్చొని డిస్కషన్ స్టార్ట్ చేసిండ్రు. వెరీ గుడ్ నిధి, ఎక్సలెంట్. ఓకే, అండ్ సెట్టింగ్ అప్ ఆఫ్ కాన్స్టిట్యూయెంట్ అసెంబ్లీ. సో కాన్స్టిట్యూయెంట్ అసెంబ్లీ మనం 6th December 1946 లో సెటప్ చేయడం జరిగింది. అంటే ఎవ్రీథింగ్ ఈజ్ సెటప్, మెంబర్స్ ఆర్ అపాయింటెడ్, సీట్స్ ఆర్ అలాటెడ్ అండ్ ఎవ్రీథింగ్. And 3 days తర్వాత we started our first meeting, right? And then when it comes to cabinet mission plan, so cabinet mission plan was sent somewhere around May 1946. This date is not really important, right? And objectives resolution, I talked about objective resolution when I was talking about preamble. So objective resolution is our present preamble. So this was actually moved by Jawaharlal Nehru in the Constituent Assembly. So objective resolution was moved by Jawaharlal Nehru on December 13, 1946. Okay, December 13, 1946. So these are some important dates that you have to remember. So 9th December ante Constituent Assembly lo first meeting jarigindani meeku gurtunchukoవాలి for the examination point of view. Next, question number 6. Administrative tribunals were given recognition through which constitutional amendment? ఏ రాజ్యాంగ సవరణ ద్వారా అడ్మినిస్ట్రేటివ్ ట్రిబ్యునల్స్ కు రాజ్యాంగ గుర్తింపు లభించింది? Write down the answer in the chat window. First, let us understand what is administrative tribunal. First, let us understand what is tribunal for that matter. What is the difference between tribunal versus court? Court and tribunal మధ్యలో డిఫరెన్స్ ఏముంది? See, court is a general court wherein all the proceedings will have to happen. It might be civil, criminal, constitutional, corporate, any matter you'll go to the court. In the court, you have to follow, a particular procedure, right? So you have to file the evidence and this affidavit, this and that. So there's a very lengthy process on the court. So what happened is that by enacting 42nd Amendment, we have established tribunals. So tribunals are the courts that are established for specific purpose. Like for example, we have NGT or National Green Tribunal. So National Green Tribunal ante environment related cases chuskuntaru. For example, we have Income Tax Tribunal which looks into income tax related cases. For example, we have NCLT, National Company Law Tribunal, which looks into cases of company laws. So tribunals are courts which are established for a specific purpose, okay? And tribunals don't have the strict process just like a court. So court, not for everything you have to pay this and that and maintain lengthy processes there in the court. But in tribunals, the process is little easy when you compare to the court. Okay. So what are administrative tribunals? So administrative tribunals are established to deal with the problems of people in administration at both state level and central level. So state government employees ki if వాళ్ళకి ఏదైనా ప్రాబ్లం ఉంటే కోర్టుకి వెళ్ళి ఎక్కువ టైం వేస్ట్ చేసేబల్ they can go to state administrative tribunal. If you are a central government employee or if you are a member of All India Service, then you can go to Central Administrative Tribunal. So administrative tribunals, earlier they were general statutory bodies. They were given constitutional recognition by 42nd Amendment Act of 1976. How many of you gave the answer as one? Yeah, 42nd. Very good, Uma. Alpha, it is actually 42nd Amendment. Okay. I hope this is clear. Did you understand what is tribunal? So tribunal ki court ki madhya difference of the court ante there is a cumbersome process, chala pedda process untadi and every matter is taken up. Tribunals are those which are established for a specific purpose. Next, question number 7. Which of the following legislation provided right to vote for women for the first time in India? India first time మహిళలకు ఓటు హక్కు కలిగించిన చట్టం ఏది? It is the Government of India Act 1919. Option 2 is the right answer. Government of India Act 1919 ద్వారా women కి first time ఓటు హక్కు కలిగించడం జరిగింది. That was for the first time. So remaining acts, some of the acts are important, like for example, Government of India Act 1935, which is very, very important. I will discuss about it when I'm talking about historical background of the Indian Constitution. And of course, we'll also talk about, Indian Independence Act as well. Indian Councils Act is relatively important, but not as important as, Government of India Act 1935. Very good, Nayak, very good, Uma, excellent. Next, 68, question number 8. Who described the Prime Minister as primus inter pares? So primus inter pares and first among the equals. Like for example, there are other ministers, right? Prime Minister is also a minister, but he is first among the ministers. All the ministers are equal, but Prime Minister is first. He is the biggest person. So Prime Minister is known as primus inter pares in a cabinet form of government. So who described this particular thing? It is Lord John Morley. So Lord John Morley described Prime Minister's primus inter pares. So this is one of the miscellaneous questions, I would say. This is one of the miscellaneous questions, I would say. So that is really important for your examination. Very good, Uma. Excellent. Next, question number 9. What is the tenure of members of Rajya Sabha? Rajya Sabha members yokka padavi kalam enta. So Rajya Sabha member yokka padavi kalam is 6 years. So Rajya Sabha is a permanent house, so there is no dissolution of Rajya Sabha every every 2 years, like 1/3 of the members will retire. Very good Alpha, very good Nayak, very good Nazia, very good Uma, excellent guys. Okay, so now if I change the question as to what is the tenure of the members of Lok Sabha, what is the answer? If I change the question into what is the tenure of the members of Lok Sabha, write it down in the chat window. Very good Nayak, very good Alpha. So the answer is 5 years. Excellent. Next, question number 10. Very good Nidhi, very good Uma. Question number 10, I would say, which article of the Constitution provides for free legal aid to the poor and weaker sections of the society and ensures justice for all? సమాజంలోని పేద మరియు బలహీన వర్గాలకు ఉచిత న్యాయ సహాయం మరియు అందరికీ న్యాయం జరిగేలా రాజ్యాంగం యొక్క ఏ ఆర్టికల్లో పొందుపరుస్తుంది? సో ద ఆన్సర్ ఇస్ ఆర్టికల్ 39A. సో under article 39A there is free legal aid that is given to poor and weaker sections of the society, for which we have legal aid clinics. Okay, so we have legal aid clinics. Most probably, we'll try to resolve the issues without actually going to the court, like over here. So it is a free legal. We'll try to provide free consultation to the people if possible. If there is a case going on already in the legal aid, there are certain lawyers who will assist you. So under article 39 capital A, which is a part of DPSP, right? So to give effect to this particular thing, Parliament has enacted a legislation which is known as NALSA, National Legal Services Authority Act. So by enacting this particular act, we gave free legal aid to poor and weaker sections. Very good guys, very good Madhavi and Indira. So if you look at other articles also which are there in DPSP, like for example 38. So 38 talks about certain principles that state has to follow. State కొన్ని principles follow కావాలంటే they have given like 5-6 principles in the particular DPSP, like to secure social order and to secure the concept of welfare state. So that particular thing is there. And we have 39. So 39 are certain policies which the state has to adopt, right? And 40 is also a very important article. 40 is a Gandhian DPSP. If somebody can guess what is 40. 40 is a Gandhian DPSP. So it talks about organization of village panchayats. Not only about the organization of village panchayats, but also to give proper powers to the panchayats so that they will function independently and effectively, right? So this is there or there under DPSP. All the options are from DPSP. So for this particular question, Article 39 option 3 is the right answer. Next, question number 11. Which of the following matters can be taken up in Lok Adalat? So Lok Adalats lo etuvanti matters ni manam teesukovachu. Okay. So I'll tell you. So in a Lok, first of all, what is a Lok Adalat, right? So Lok Adalat is a court. Lok is people. So Lok Adalat, we will actually translate it to people's court. Okay. So it is not a proper court, I would say, but there are eminent people who will come there and they'll try to resolve, the issues related to the people. Like for example, there is some dispute between A and B, maybe land related, or he has to give some money or whatever it is. So for this issue kosam court ke anavasaranga time waste cheyable. If you go to Lok Adalat, there we'll try to actually solve the problem without actually going to the court, and we will actually try to enforce it quickly without any passing of judgment and stuff like that. Oh my gosh, so it's really hot over here. Let me just turn on the fan. You guys can tell me like if there's any background voice. Okay, so in Lok Adalat, you can actually deal with land acquisition courts cases. You can deal with electricity matters, and you can also deal with housing finance matters. Guys, if there's any background disturbance, just let me know. I'll turn off the fan. Otherwise, it's okay. I'll have to continue. Right. So what are non-compoundable offenses? So non-compoundable offenses are those offenses which are of serious nature, and ఒకసారి ఒక offense జరిగిందని once a case is filed, both the parties cannot come and compromise. So compromise avadanik undadu in non-compoundable offenses. So these issues cannot be taken up by Lok Adalats. So for that matter, 4 is the right answer. Land acquisition cases, electricity matters, and housing and finance. 1, 3 and 4 is the right answer. I hope this is clear. Next, very important question. Which of the following articles of Indian Constitution refers to special provisions with respect to the National Capital Territory of Delhi? So which is known as NCT of Delhi, National Capital Territory of Delhi, because Delhi is there in a very specific and in a very strategic location, I would say, because it is the capital of India. Okay, so if you go in the Delhi, so there are it's a very high it requires high security, because all the higher national officials like president, vice president, and all are staying in Delhi. So some special provisions are made with respect to police, with respect to administration, and with respect to legislative assembly and stuff. So it is given under Article 239 AA. Okay, very good, Alpha. This question will repeat, sir. What does that mean? Like, are you saying that this question will repeat, or you are asking me whether this question will repeat? There are chances, guys. There are chances that every question might get repeated. So please make sure that you are remembering all the questions that I am discussing in the classes. Right. 73. The National Commission for Backward Classes is constituted under which of the following article of the Constitution of India? NCBC, National Commission for Backward Classes, there under which article? 336, 339, 338 or 338? So the answer is 338 capital B. Earlier, okay, so earlier NCBC was a statutory body. What is the meaning of statutory body? So statutory body is a body that is established by law, which means Parliament or state legislature will enact a law, and it will be created as a body. But in 2018, by enacting 102nd Constitutional Amendment Act, 102వ రాజ్యాంగ సవరణ ద్వారా NCBC we gave a constitutional status. What is constitutional status? When we give a constitutional status, it becomes a constitutional body. So constitutional body always comes with an article because it is mentioned in the constitution, right? So that is why Article 338B talks about NCBC. Like for example, if I talk about NHRC or SHRC, National Human Rights Commission and State Human Rights Commission, both of them are not constitutional bodies. They are statutory bodies. because these are not mentioned in the constitution, right? They are mentioned by an ordinary law which is made by the parliament. Next, which of the following agencies has been described as a caged parrot by the Supreme Court of India? క్రింది ఏ సంస్థ క్రింది ఏ సంస్థలో కింది ఏ సంస్థని భారతీయ సుప్రీంకోర్టు పంజరంలోని చిలుకలా అభివర్ణించింది? సో ద ఆన్సర్ ఇస్ Central Bureau of Investigation, or CBI. Very good, Alpha, excellent. So what exactly is this one? So earlier, like I think around 2018, around 2018 and 17, Supreme Court used this particular term, right? So what Supreme Court opined that CBI is not acting independently. It is actually doing whatever central government ఏం చెప్తే అది చేస్తుంది. మీ మాస్టర్ వాయిస్ ని you are speaking out. So that is what Supreme Court commented on CBI, caged parrot speaking its master's voice. So that is what Supreme Court told. So CBI is the right answer. Next question, number 15. Which among the following articles was inserted in the Constitution by 42nd Amendment Act of 1976 in view of India becoming a signatory to Stockholm Conference of 1972 on environment? So పర్యావరణంపై 1972 స్టాక్హోమ్ కాన్ఫరెన్స్ కు భారతదేశం సంతకం చేసినందున రాజ్యాంగం 42వ రాజ్యాంగ సవరణ ద్వారా ఏ ఆర్టికల్ ను చేర్చారు? సో ఏ ఆర్టికల్? ద ఆన్సర్ ఇస్ ఆర్టికల్ 48A. So what exactly is this Stockholm Conference on Environment? So in Stockholm Conference on Environment, we made a pledge to protect the entire human environment, that is protecting the plants, protecting the animals, and protecting even the human beings, let us say, right? So for this particular thing to give effect to Stockholm Conference, Parliament has enacted the 42nd Amendment and 48A was introduced. So 48A talks about the protection of environment, protection of wildlife and stuff, right? So and then we have other DPSPs also, like for example we have 45. Earlier 45 was giving right to education, right? But after the enactment of 86th Amendment, 45 talks about early childhood care of children who are from 0 to 6 years. 0 to 6 years పిల్లల యొక్క కేర్ గురించి ఆర్టికల్ 45 is talking. 47 and 47A, B and C, whatever is it. 47 is talking about protection of public health. In 47, there is a Gandhian DPSP which talks about prohibition of alcohol. So 47 లో ఏమందంటే పబ్లిక్ హెల్త్ ని ప్రొటెక్ట్ చేయాలి. సో దానికోసం ఇఫ్ దెర్ ఇస్ ఎనీ డ్రగ్ దట్ ఈస్ causing any damage, huge damage to the human kind, so then that should be banned by the government. So that is what is given in DPSP, but this is not enforceable because it is just a DPSPs. DPSPs are not enforceable in a court of law. So that is what is about this one. Very good, 4 is the right answer. Next, 16. Which of the following is not a main organ of the UNO? కింది వాటిలో UNO, which is United Nations Organization, లో ప్రధాన అవయవం కానిది. సో ఆర్గాన్ is అవయవం, so whatever it is. So organ of UNO. What do you think is the answer? Okay. So UNO or United Nations Organization was enacted by the UN Charter. UN Charter 1945 లో ఈ చార్టర్ డ్రాఫ్ట్ చేయడం జరిగింది. సో మనం ఈ చార్టర్ డ్రాఫ్ట్ చేసినప్పుడు there are certain important main organs which are functioning under the UNO. What are those organs? No, Alpha, that is not the answer. Let me just explain you, right? So there are certain organs, like there are total of 6 organs in the United Nations. First one is General Assembly, okay. Second one is Security Council. Third one is Trusteeship Council, and fourth one is Economic and Social Council, right? And then fourth one we have International Court of Justice, or ICJ, okay. And then we also have the UN Secretariat. E6 organs, 1 2 3 4 5 6, these are the main organs of the United Nations Organization which were mentioned in the UN Charter of 1945. Your మిగతా ఆర్గనైజేషన్స్ ఏవైతే ఉన్నాయో, ఫర్ ఎగ్జాంపుల్ యునైటెడ్ నేషన్స్ ఎడ్యుకేషనల్ సైంటిఫిక్ అండ్ కల్చరల్ ఆర్గనైజేషన్ అంటే యునెస్కో. ఓకే, దీని తర్వాత there is something known as UNICEF. Okay, so all of these are not the main organs of United Nations. Okay, these are the 6 organs of UN, and please remember, no Uma, so 4 is the right answer, right? Not a main organ of UN. UNESCO is the right answer. 77, under the Indian Penal Code, nothing is an offence which is done by a child under భారతీయ శిక్షా స్మృతి అంటే ఐపీసీ ప్రకారం ఏ వయసులో పిల్లలు చేసేది నేరం కాదు, అంటే సడన్ ఏజ్ గ్రూప్ ఉన్న వాళ్ళు ఎవరు తప్పు చేస్తారు. వెరీ గుడ్ ఉమా, ఎక్సలెంట్. సో ద ఆన్సర్ ఇస్ 7 years of age. So 7, somebody who is below the age of 7 is considered as a child, right? So anybody who is a child below the age of 7 years under section 82 of IPC, you know, whatever he is committing, it is not a crime. So section 82 of IPC talks about general exceptions. In chapter 4 we have general exceptions. So under general exceptions, you know, child is also an exception. If a child is committing any offense, it is not a crime because people don't know. Very good Nazia, very good Alpha. Next, a very important legal maxim, the maxim de minimis non curat lex. Okay, means sameta de minimis non curat lex ante enti. I explained this in the class. Very good Alpha, very good, excellent. So law would not take action on small and trifling matters. Okay, chinna matters gurinchi law will not bother much, or it won't give punishment about the same. Very good Nidhi, excellent. So that is de minimis non curat lex. So minimus ante minimal things, non curat ante law, it does not take action. Lex is law. What is the meaning of rex? What is the meaning of rex? Answer it down in the chat window. What is the meaning of rex? Very good Alpha, excellent. So rex is king, lex is law. Next, 79, a contract by which, okay, one party promises the other to save from loss, okay, which means this loss may be caused by either the conduct of promiser, that means either by A, or by the conduct of any other person. This is known as what? అంటే ఒక వ్యక్తి ప్రవర్తన వల్ల లేదా మరేదైన వ్యక్తి ప్రవర్తన వల్ల సంభవించే నష్టం నుండి రక్షించడాన్ని ఒక పార్టీ ఇతర పక్షానికి వాగ్దానం చేసే ఒప్పందాన్ని ఏమంటారు? వెరీ గుడ్ Alpha, very good Nayak. Uma, it is okay, you gave me answer for the previous question or what? See, I'll give you an example, right? So for the very good example of contract of indemnity is insurance companies. So how insurance company works, right? So you will be paying a premium to insurance company. Okay, if for example you got, let us say, fever, you got dengue and you are admitted in hospital. Okay, now dengue is caused by whom? Dengue is caused because of A or because of B? So dengue is actually caused by some other party. Okay, it is a mosquito. Okay, so because of that mosquito you have suffered from dengue and you are admitted in the hospital. So now just because of other party's negligence or because of A's negligence, due to anything, if any damage is happening to you, insurance company is going to compensate for that particular thing, right? That is known as indemnity. So indemnity ante nashta pariharam. So meeku jarigina nashtaanni insurance company is going to reimburse it. So that is what is known as indemnity. Let me also quickly, run you through other options. Let me erase this first. I hope you understood what is indemnity, right? So indemnity happens, like for example there is life insurance. So death jarigina, for example death might happen through anything. So if death is happening, the insurance company will pay you some amount based on whatever is discussed. First thing is contract of bailment. Bailment ante enti? So bailment ante you are giving your goods for a specific purpose. Like for example, you are giving your shirt to a tailor. You are giving a cloth to a tailor to convert into a shirt, right? So here, just because you are giving your cloth to tailor, does it mean that the ownership is transferred to him? You gave a cloth to tailor. మీరు టైలర్ దగ్గరికి వెళ్ళి టైలర్కి క్లాత్ ఇచ్చారు. టైలర్ క్లాత్ ఇచ్చినంత మాత్రాన టైలర్ ఓనర్ కాదు కదా దానికి. సో యు ఆర్ ద ఓనర్. సో యూ గేవ్ ఇట్ ఫర్ ఎ స్పెసిఫిక్ పర్పస్. ఆ పర్పస్ అయిపోయిన తర్వాత యూ విల్ గెట్ ద షర్ట్ బ్యాక్, రైట్? So that is known as contract of bailment. You are temporarily lending the goods for a specific purpose. Next, contract of pledge. So what is a pledge? So pledge is you are giving your movable property as a security for repayment of loan or security for anything. Like for example, A has lended like a money of 1 lakh rupees to B. A B 1 lakh rupees ఇచ్చిండు. So 1 lakh rupees ఇచ్చినందుకు A is going to take, let us say, B's iPhone as a security, which is worth 1 lakh. So here in pledge, it has to be only movable property. So movable property అయితే ఏ ప్రాపర్టీని అయితే మనం మూవ్ చేయగలుగుతాం, ఒక ప్లేస్ నుండి ఇంకో ప్లేస్ తీసుకెళ్ళగలుగుతాం, that is known as pledge. If you keep immovable property as a security, then it is known as mortgage. So అంటే ప్రాపర్టీ పేపర్స్ 1 lakh rupee worth ప్రాపర్టీ పేపర్స్ పెడితే that is mortgage. Movable goods పెడితే you call it as a pledge. Next one is contract of guarantee. So what is a contract of guarantee? Let me explain it over here. See, for example, let me take this particular thing. Yeah, A is there, right? A is giving money to B, 1 lakh rupees. A is giving 1 lakh rupees to B. Now, C comes here and promises to A that if B does not pay 1 lakh rupees, I will give you the guarantee. Okay, I am the surety person. Which means that if B is not paying 1 lakh rupees, then C will come and pay. So here A and C are entering into a contract of guarantee. C is guaranteeing to A, saying that, dear A, B will definitely give you 1 lakh rupees. If he is not giving, it is my guarantee that I will give you. That is known as contract of guarantee. Whereas in indemnity, it is not only because of C, it can be due to any other person's default also. So in that is a different case altogether. I hope you are clear with these terms: bailment, guarantee, pledge and indemnity. Arthamaida ee concepts, these 4 concepts? Yes or no? Please give me very quick yes, so that I'll proceed to the next question. Question number 80. Dash has been introduced by the Consumer Protection Act of 2019 for resolution of consumer disputes. అంటే వినియోగదారుల వివాదాల పరిష్కారం కోసం వినియోగదారుల రక్షణ చట్టం 2019 ద్వారా డాష్ ప్రవేశపెట్టబడింది. సో ద ఆన్సర్ ఇస్ మీడియేషన్. మీడియేషన్ అంటే ఏంటి? ఫర్ ఎగ్జాంపుల్, there is a dispute. I purchase this webcam, right? So when I purchase this webcam, let us say there is some problem in the webcam. So the owner is Logitech. Okay. Now, Logitech and I will go over here. There will be a mediator. So what will the mediator do? Mediator will try to resolve the issue. Okay, that is known as mediation. Whereas in arbitration, so arbitration ante there is an arbitrator. Okay, so arbitrator, he will pass an award. Okay, award ante not the prize. Ante oka order pass chestaru. Aa order anedi ee 2 parties మీద బైండింగ్ ఉంటుంది. సో జుడిషియల్ సెటిల్మెంట్ ఈస్ గోయింగ్ టు ద కోర్ట్. సెల్ఫ్ హెల్ప్ అంటే సెల్ఫ్ హెల్ప్. సో ఎవరి వాడు హెల్ప్ చేసుకోవాలి. సో మీడియేషన్ అంటే మధ్యవర్తిత్వం. సో ఒక మనిషి మధ్య కూర్చొని హీల్ ట్రై టు రిజాల్వ్, హీ విల్ నాట్ పాస్ ఎనీ ఆర్డర్. మీ ఇద్దరు సెటిల్ అయ్యేలాగా చూసారు. వెరస్ ఇన్ ఆర్బిట్రేషన్ ఇట్ ఈస్ అవుట్ ఆఫ్ ద కోర్ట్ సెటిల్మెంట్, బట్ దేర్ ఇస్ అన్ ఆర్డర్ ఓవర్ దేర్, రైట్? సో మీడియేషన్ ఇస్ ద రైట్ ఆన్సర్. ఇస్ దిస్ క్లియర్? వెరీ గుడ్ నాయక్, వెరీ గుడ్ ఉమా. నెక్స్ట్, which of the following is not a fair use of copyrighted work? So copyrighted work ante, for example, I wrote a book, right? So if I wrote a book, all the copyrights are there with me. So if somebody wants to use, they cannot use it for this purpose. What is that purpose? Copyrighted chesinaటువంటి ఒక anything, so it cannot be used for what? So it cannot be used for commercial purposes. Very good Alpha, excellent, very good Nidhi. So for research, you can use my book. For criticism, you want to criticize my book, you can definitely criticize. You want to review my book, a lot of reviewers on YouTube, so you can definitely review it. But for commercial purposes, matlab you are copy pasting my book and selling it on your name and you are making money out of it, right? So that is not allowed. Okay, so this is not a fair use of copywriting. Very good, Nayak. Very good, Uma. Next, the criminal law amendment made after Nirbhaya incident refers to commission of rape resulting in PVS of the victim. So PVS ante enti. So Nirbhaya gang rape incident happened in 2012 in Delhi. So after this, certain amendments were made to criminal law. Verma committee was appointed. Protection of certain acts were enacted by the union government. So in the criminal law amendment, PVS is included. What is the meaning of PVS? Very good, Nidhi. So persistent vegetative state. So what is a persistent vegetative state? See, you might have heard about this particular thing, what is known as coma. So what happens when you go to coma? So when you go over there, so you won't be able to see anything, you won't be able to eat, you won't be able to do anything. So after coming out from coma, some people, they'll actually forget certain people. Okay, like for example, I'm there, A is my friend. After coming out from coma, A might not recognize me. If you show him, he said, okay, who is this person? I did not see him anytime. So that particular state is known as persistent vegetative state. Okay, rape resulting in persistent vegetative state, which means after rape, if the girl or the woman is resulting in persistent vegetative state, there is a very strict punishment that is imposed under criminal law. Okay, so that is persistent vegetative state. So persistent vegetative state is a state which generally happens, where you won't be able to recognize people properly. So something like that. 83. Fiduciary relationship between two parties is based on. ఇద్దరు వ్యక్తుల మధ్య fiduciary సంబంధం దేనిపైన ఆధారపడి ఉంటుంది. So the answer is utmost trust and confidence. Like for example, lawyer and client. So lawyer and client. So here client goes to the lawyer because he trusts that particular lawyer and he has confidence in him. And whatever the client is communicating to the lawyer, he will not be disclosing those things outside whenever so that it will not be be in disadvantage of the client, right? So fiduciary relation, for example, I am there, okay, so I and my CA, we are doing our CA, I appointed a CA to look after my account. So here it is based on trust and confidence I'm giving this particular thing. So when he breaches this particular thing, then it is a violation of fiduciary relationship. That is fiduciary under based on trust and confidence. Next, which of the following orders cannot be passed under Protection of Women from Domestic Violence Act 2005? గృహ హింస నుండి మహిళల రక్షణ చట్టం 2005 ప్రకారం కింది వాటిలో ఏ ఉత్తర్వులు ఆమోదించలేరు? What is the answer? The answer is restitution of conjugal right. What is restitution of conjugal right? So it is getting back the right to live together. So conjugal rights, to put it in simple term, it is the right of a party to a marriage, that is husband or wife, to cohabit with each other, which means they have the right to have sex with each other. So this particular thing is known as restitution of conjugal rights. So you're getting those rights back. Like for example, if people are not living together, okay, so you go to the court and you get an order for restitution of conjugal right, which means you want those rights back, right? That is restitution of conjugal. This cannot be issued under Domestic Violence Act. Okay, so under Domestic Violence Act, there is a protection order, there is compensation order, and there is a custody order, but there is no restitution of conjugal rights. Next, 85. Which among the following presidents of India was elected as chairman of UNESCO? What is UNESCO? I discussed it in the previous slide. United Nations Educational, Scientific and Cultural Organization. In the UNESCO's executive board, who was the president? So it was Dr. S. Radhakrishnan. So Dr. S. Radhakrishnan was elected chairman of the executive board of UNESCO. Next, yeah, very important and interesting observation. Look at this. Directive principles are like a check on the bank, payable at the convenience of the bank. Like for example, this is a check. I have a check with me. Now if I write over here, like let us say this is my checkbook, if you can see, here I'll be writing like let us say 1 lakh rupees, I'm transferring it to somebody. Okay. Now I'll give this check to the bank. Like for example, I have to deposit in the State Bank of India. If I go to the bank, so generally when will the bank make payment? Bank will make the payment if there is if there is money in my bank account. But here there is a check. It is payable at the bank, but at the convenience of the bank, which means that here if bank wants to pay, bank will make the payment. If bank does not want to pay, bank does not make. Here bank is a government. Okay, DPSPs are there are policies, but it is up to the government whether government has to implement these DPSPs or not. DPSPs ఉన్నాయి కానీ వాటిని ఎన్ఫోర్స్ చేయడం చేయకపోవడం అనేది it is in the hands of government. Very good Nayak. So the answer is Professor K.T. Shah. So K.T. Shah talked about this particular thing. Next, 87. The National Commission for Scheduled Tribes presents an annual report to which of the following? NCST, షెడ్యూల్ తెగల జాతీయ కమిషన్ క్రింది దేని ఎవరికి వార్షిక నివేదికను అందజేస్తుంది? వెరీ గుడ్ ఎక్సలెంట్ నిధి. సో ద ఆన్సర్ ఇస్ ప్రెసిడెంట్. సో NCST or National Commission for Scheduled Tribe is a constitutional body under Article 338A, right? So among other things, here the NCST will present annual report to the president. So in the report, NCST will talk about the development that is done in the scheduled tribes. If there are any challenges, whatever it is there, so it will be communicated to the president by the NCST or National Commission for Scheduled Tribes. Very good, excellent. Next, 88. The first women governor of a state in free India. So free India and independent India after 1947. The first governor of state in free India. What is the answer, guys? What is the answer? A very easy question. Very good Nidhi, very good Nayak, excellent. So the answer is Sarojini Naidu. So what is the nickname of Sarojini Naidu, if anybody remembers correctly? And Sarojini Naidu was the governor of Uttar Pradesh. Note this down. Very good Srikanth, excellent. Uma and Nayak. Nightingale of what? Very good Srikanth. Nightingale of India. So Sarojini has a title, that is Nightingale of India. Next. How many times President of India can seek re-election to his post? భారత రాష్ట్రపతి తన పదవికి ఎన్నిసార్లు తిరిగి ఎన్నికను కోరవచ్చు? Write it down. Very good Nidhi, very good Alpha. So the answer is any number of times. There is no bar on re-election to the President of India. So once you get elected, you can also get elected any number of times. Who was the longest serving President of India? Very good. Alpha, Srikanth, Nayak, Uma, Nazia. Very good, guys. Who is the longest serving President of India? అందరికన్నా ఎక్కువ రోజులు ఎవరు who served as a president? Very quickly, I have to proceed to the next question. Very good Srikanth, very good Alpha. Nayak Jawaharlal Nehru is not the president, he was a prime minister. So Babu Rajendra Prasad is the right answer. Next. The president nominates 12 members of Rajya Sabha according to. 12 మందిని ప్రెసిడెంట్ నామినేట్ చేస్తాడు మనం డిస్కస్. వెరీ గుడ్ ఉమా. So based on what? So their performance of office bearers of cultural societies, or based on recommendation made by vice president, their role played in political setup of country, the distinction in their field of science, art, literature, and social service. Very good, very good. Nidhi, Alpha, Nazia, Shrikant, you have to correct it. The answer is 4. Anybody who has distinction in the field of science, art, literature, and social service. So, according to Article 80 of the Indian Constitution, President of India will appoint these people. Like, for example, under this, by using this particular article, certain members were nominated to Rajya Sabha. For example, Sachin Tendulkar, Mary Kom, boxer, right? Recently, former Chief Justice of India Ranjan Gogoi was also appointed to Rajya Sabha, right? Yes, no problem. Very good, Srikanth. Very good, Uma. So the answer is 4. Under Article 80, President will nominate. Next, the contracts entered by Government of India are expressed in the name of భారత ప్రభుత్వం నమోదు చేసిన ఒప్పందాలు వీరి పేరుతో స్వీకరించబడతాయి. ఎవరి పేరు మీద స్వీకరించబడతాయి? వెరీ గుడ్ ఆల్ఫా, వెరీ గుడ్ నిధి, ఎక్సలెంట్ గైస్. సో ద ఆన్సర్ ఇస్ ప్రెసిడెంట్ ఆఫ్ ఇండియా. వెన్ ఐ వాస్ టాకింగ్ అబౌట్ యూనియన్ ఎగ్జిక్యూటివ్ గురించి మాట్లాడేటప్పుడు ఐ టోల్డ్ యూ వన్ థింగ్. ఆల్ ఎగ్జిక్యూటివ్ యాక్షన్స్ ఆఫ్ the union are taken in the name of President of India. How many of you remember this statement? Only those who paid very close attention in the class will be able to. Okay, Indira, your comment has come little late, but that is correct. How many of you remember this particular statement that I made in the class, that all executive actions of the union are taken in the name of President? Right. So that is important. And let me proceed with the next question. What is the meaning of Latin maxim Nemo judex sua in causa? I explained this in the class, so I am expecting an answer from you guys. Nemo judex in causa sua. Nemo judex sua in causa is also appropriate. What do you think is the right answer? Very quickly. Well done. No, Alpha. You gave 2 answers. Which one should I consider? Very good, Alpha. Excellent. 2. No person shall be a judge in his own cause. And for example, if you are a party to a case, or if you have specific interest in the case, you cannot be a judge, right? That is known as nemo judex sua in causa, because this is against the principle of natural justice. Very good, Srikanth and Nazia. See, you might have seen in certain old movies, right? So in old movies, father is a judge, okay, and one side lawyer is judge's daughter. This thing will happen. This happens only in movies, not in the courts, right? So when there is a specific interest, okay, so whether it is your father or mother or maybe somebody, or you are dealing, you have some or other way you have any interest or any link to the case, you should not be a judge. Okay, that is really important, because recently, if you remember, our former Telangana High Court Chief Justice and currently a judge in the Supreme Court, Justice Hima Kohli. So she was actually given a matter relating to Future Retail. So Future Retail is the company which holds, Big Bazaar. Now Big Bazaar is closed, and Heritage and all of these companies, right? So there was a case relating to Future Retail, and it was allotted to Justice Hima Kohli. But Hima Kohli said that I am not going to deal this particular case. Please allot it to a different judge. Why? Because Hima Kohli told she is holding certain shares in this particular company. ఈ కంపెనీలో హిమా కోహ్లీకి షేర్స్ ఉన్నాయి. So as there is a specific interest, she is not going to deal in that particular case, because there might be partiality. There is a bias for this particular thing. So that is why nobody shall be a judge in his own cause. Next, 93. We'll try to finish like at least 100 today. 100 is like 40 questions, right? Which of the functions may not be delegated by the legislature? అంటే లెజిస్లేచర్ అంటే శాసనసభ ద్వారా ఏ విధులు ఇతరులకు అప్పగించకూడదు? What do you think? Just make an educated guess. Even if you did not study, you will be able to answer it properly. What do you think? Even if it is wrong, it's not a problem. Just try to give me some other answer. What do you think, guys? Very good, Alpha. No, see, what are essential legislative functions? Essential, ముఖ్యమైన శాసన బిల్లు అంటే making the law. Okay, so making the law is the most essential part of function of legislature. It cannot be delegated, right? So what do you mean by delegating? So delegating means like once a law is made, ఒక law తయారు చేసిన తర్వాత once it gets the assent of governor or the president, it is not enforceable directly, right? So an order has to be issued in the gazette or a government order has to be issued. Order lo all the things will be mentioned, right? ఈ law ఎప్పుడు ఎన్ఫోర్స్ అవుతుంది, ఎక్కడ అప్లికేబుల్ ఉంది, ఎక్కడ అప్లికేబుల్ లేదు, and what is the application of executive. All of these things are delegated by the legislature to the executive. So executive, that is the officers who are there, IAS officers and IPS officers, they will actually frame the rest of the thing, right? Actual legislation, asalina law, it is made by the legislature, so it cannot be delegated to somebody else, that is to the executive. Is this clear? Application, no, Nazia and Naik, please correct yourself. So application of existing laws, like for example, if Consumer Protection Law of 2018 is repealed, so its application is not there, right? So that will be meant, that can be delegated to the executive. Executive can decide on that. So 4 is the right answer. Next. Yeah, very interesting question, I would say. Dash is an attempt by cyber criminals, okay, posing as legitimate institutions, usually via email, to obtain sensitive information from targeted individuals. Dash అనేది చట్టబద్ధమైన సంస్థలాగా నటిస్తూ సాధారణంగా ఈమెయిల్ ద్వారా లక్ష్యంగా చేసుకున్న వ్యక్తుల నుండి సున్నితమైన సమాచారాన్ని పొందేందుకు సైబర్ నేరస్తులు చేసే ప్రయత్నం. So that is known as phishing. So phishing is something which is a thing, like for example, I am there, right? So my email ID, people will create an email ID, like my email ID is trinathreddy@lawcet.com, for example, let us say, right? Now somebody will keep Trinath and 1.123 so that you won't recognize, and then send you an email saying that hi, you pay 10,000 rupees extra as course fee, or to attend YouTube class you just pay 1 lakh rupees. So somebody might ask you think, okay, Trinath is asking, so I have to make the payment, otherwise I might not get access, and they'll take the money from you, or they'll take some sensitive information, maybe your password, okay, or maybe somebody else's information. That is known as phishing. Hacking is stealing the data, from your server or from your computer. Next thing is skimming. So skimming is actually dragging information through a process. Like for example, this is an ATM, right? So in ATM, or there is a POS machine. So POS is point of sale. So where you swipe your card. So these machines, they can keep certain equipments, and they will be in a position to actually skim your data, that is your password and CVV and all of these things, and they will create fake credit cards and debit cards, and they will use your cards. So that is known as skimming. And second one is denial of service attack. So this is a really important thing, I would say. Like for example, in denial of service attack, you will create artificial demand by creating various fake computers. Like for example, let me tell you, I am making a system that there are only 10 seats left in the course. Okay. Now what the cybercrime fellow will do, he will actually create 10 fake computers, and he will click on payment, so that it will show in other people that the seats are filled, but nobody has purchased. So he's creating artificial demand, and this particular fellow later on, so because of this particular fellow's hacking, there is denial of service to the actual buyer. Okay, this happens on big billion days of Flipkart and Amazon also. People will try to actually restrict the purchasing of normal people like you and me. You and me want to produce, there is only limited stock. When somebody else, he creates fake computers and shows that he's buying, there is a denial of service attack. Okay, these are certain important cyber terms which you have to remember. I hope these are clear, right? 95. Which of the following statements in relation to adultery in India is correct? భారతదేశంలో వివాహేతర సంబంధించి కింద స్టేట్మెంట్లో ఏది సరైనది? So first, let me explain you what is adultery, because okay, Nidhi has correct, very good, right answer. It is not a crime but a ground for matrimonial remedy. I'll explain you what is that. See, adultery is having a illegal relation. Now I cannot call it illegal because adultery is not illegal, right? So this is A, right? A is married to a female, that is AF. Okay. Now both of them has to be married, okay, not live in relationship, nothing. Now B, let us say B is there, okay. B and AF, both of them are having sexual intercourse. Both of them are having sex, okay. It is consented sex, it is not a rape. AF is also interested, B is also interested, both of them are having sex. Now both of them are having sex without the permission of A, so if there is permission of A says okay, have sex with my wife, then that is not adultery, right? If AF and B are having sex without the permission of A, then A is the aggrieved party in adultery, okay. The husband of the woman is the aggrieved party, and he can go and file a case, right? He can go and file a case against B. Now here B is a culprit, but this was there previously under section 497 of IPC. But in 2018, in Joseph Shine versus Union of India, Supreme Court told adultery is not illegal, but it can be a ground for matrimonial remedy. Like for example, AF has had sex with B, so that is why A will say that okay, you are having sex with that particular person, go, I am not going to stay with you. So we will get apart and we'll get divorced. It can be a ground for divorce, okay, but it is not illegal. It is not a crime in India. Is this clear? Did you understand what is adultery? Don't worry if you don't understand also, because in criminal law classes I'll explain you again like what is adultery, and what is rape, and what is theft, what is extortion, what is robbery, and everything, right? Next, amniocentesis. What is amniocentesis? Test to determine health and sex of fetus, test to determine ketone bodies in urine, test to determine breast cancer, test to detect HIV. Very good, Nidhi. Oh my gosh, why this is coming? Yeah. Amniocentesis is a test to determine health and sex of a fetus. అంటే పిండం యొక్క ఆరోగ్యం మరియు లింగాన్ని నిర్ధారించడానికి పరీక్ష. So determining sex is illegal and it is a punishable offense. It's a criminal offense in India. Right? You cannot determine the sex of the fetus because of that there are a lot of feticide. What is a feticide? That is killing the fetus inside, right? So that is many of the, especially if the fetus is a female, so people tend to kill that. So that is why it is not allowed in India. To determine the health, doctors will be able to see, but revealing it to the parent or to anybody else is not allowed in India. Very good, very good. Yeah, abortion. See, abortion is a gender neutral term, right? Abortion is like if there is a body in the male, it can be male body or it can be female body, okay. So abortion is a general term, feticide is a scientific term, like killing the fetus. Female feticide is killing the girl child inside inside her mother's womb. So that is what. So feticide is a scientific term of abortion. Which of the following act repealed the Identification of Prisoners Act 1920? So the Identification of Prisoners Act, so it will actually give permission to the authorities to collect certain identifiable evidences or maybe any information from the people who are in jail, like prisoners under jail lo unnava. So the answer is the Criminal Procedure Identification Act 2022, very recent legislation, so you have to remember it. 98. People in the rural areas of Telangana state used to sell and purchase lands through agreements made on plain papers without registering the same. These transactions are known as తెలంగాణ రాష్ట్రంలోని గ్రామీణ ప్రాంతాల్లోని ప్రజలు భూములను రిజిస్ట్రేషన్ చేయకుండా సాదా కాగితాలపై చేసుకున్న అగ్రిమెంట్ల ద్వారా విక్రయించడం మరియు కొనుగోలు చేయడం వంటివి చేసేవారు. ఈ లావాదేవీలను ఏమంటారు? సో ద ఆన్సర్ ఇస్ సాదా బైనామా. సో సాదా ఇస్ అ ప్లెయిన్ థింగ్. సో అనే ప్లెయిన్ పేపర్. సో what is a pahani? So pahani or an adangal. Pahani is also known as adangal. So this is a legal document relating to a land which is issued by a tahsildar. Okay, so tahsildar is a officer at the mandal level or the block level who issues this particular pahani, or which is a proper legal document, right? So there is something known as this Porambok lands. Porambok lands are generally the lands that are not, so people are not having complete ownership over them, but government is assigning these lands, right? So government is assigning certain lands to people in rural areas, like people who don't have land, and so those lands are generally known as Porambok lands, right? So but Sada Bainama is a property where it is registered on a normal white paper, whereas Pahani is a proper legal document that is issued by a Tahsildar. So that is what you have to remember. Question number 99. The willful disobedience of judgment of a court amounts to defamation, civil criminal contempt and sedition. కోర్టు తీర్పు యొక్క ఉద్దేశపూర్వక అవిధేయత అంటే జడ్జ్మెంట్ ని పాటించకపోవడం ఈ కింది వాటిలో దేనికి దారితీస్తుంది? పరువు నష్టం, క్రిమినల్ కోర్టు ధిక్కారం, సివిల్ కోర్టు ధిక్కారం, దేశద్రోహం. వాట్ ఈస్ ద ఆన్సర్? What do you think is the answer, guys? Oh my gosh. Okay. Yeah, very good, Nidhi. So the answer is civil contempt of court. So willful disobedience ante court gave a judgment and you are not following it, then it is a civil contempt. Okay, but when you write something or when you speak something or when you make some action which is going against the integrity of the court, which is obstructing the court proceedings, then it becomes a criminal contempt. Okay, so if you are not following it, then it will be a civil contempt of court. Okay, so in civil contempt they'll ask you to pay a fine, whereas in criminal contempt they can send you to jail also, right? So the answer is civil contempt of court. Willful disobedience ante కావాలని జడ్జ్మెంట్ పాటించకపోవడం. Next, which union territory has its own high court? I am expecting some answers from you guys. Which union territory has its own high courts? Well done, Alpha. Well done, Srikanth. Excellent, guys. So the answer is Delhi. So Delhi is a union territory which has its own high court, and now we also have the union territory of Jammu and Kashmir, which also has its own high court. But of course it is sharing with Ladakh, but there is a proper high court. Whereas in Lakshadweep, Puducherry and Andaman and Nicobar Islands, the high court is actually they share a common high court. Like for example, if you look at Andaman and Nicobar Islands, right? So they fall under Calcutta High Court. Andaman and Nicobar. So Lakshadweep and Puducherry, they fall under Kerala High Court. Lakshadweep falls under Kerala High Court. So that is what. So we will discuss till 110 because I have to complete at least one paper today. Kerala. And under this side, so Andaman and Nicobar Island is at this side, right? So here it falls under Calcutta High Court. Lakshadweep is there on this side, falls under Kerala High Court. Okay. 101. What is ex parte order? Ex parte order ante enti? What is an ex parte order? Very important. Very good. Excellent, Alpha, Nidhi, Nayak. Very good, guys. So ex parte is an order passed by the court in the absence of concerned parties. Like what happened in 2020, In 2021, I filed a case in the District Consumer Disputes Redressal Commission against somebody, against some restaurant and bar, right? So what they did is that I filed a case and they did not actually come to the court. They did not give any reply to the court. So after 2 or 3, summons, firstly court asked the bar to come. Dear bar, a case is filed by Thrinath against you. Come and attend the court. They did not come. Second time also they did not come. Third time the court has set down this particular party as ex parte. అంటే ఇప్పుడు నువ్వు లేకుండానే ప్రొసీడింగ్స్ జరుగుతాయి. ఆల్రెడీ నీకు 2 సార్లు ఛాన్స్ ఇచ్చిన. I asked you to come twice, but you did not come. So I'm setting you as ex parte and order will be given in the absence of you. Right? So that's how the order was passed. So when a party is not coming to the court, even after multiple times the court is calling and you're not coming, then court will set you as ex parte and ex parte order will be issued. I hope this is clear. Right? Next, 102. Within the meaning of provisions of Transfer of Property Act 1882, immovable property does not include స్థిరాస్తి అంటే ప్రాపర్టీ మనం ఏదైతే కదల్చలేము. what are included under 1882 Transfer of Property Act? TOPA, which is known as TOPA. So a very slightly difficult question, I would say. The answer is standing timber, growing crops and grass. They are immovable properties. Okay. So whereas standing timber or grass, so or ante idi leda adi annadu. So this cannot be the answer. Standing timber, jewelry and crops. Is jewelry immovable property? Is jewelry an immovable property? Can you move jewelry from place A to place B? That is my question. Right. So jewelry is a movable property, right? So option 2 is also excluded. Only grass. Okay, because in Transfer of Property Act, timber is there, crops is there, grass is there. So only grass also cannot be the answer. So standing timber, growing crops and grass, so all of these are immovable property, because timber you have to cut it down, crops you have to cut it down, grass you have to cut it down. You couldn't get the question. Okay, I'll explain it once again. Okay, see, in transfer of property, what is the definition of immovable property? So immovable property ante in, so ee moodu ante timber, crop and grass, so these 3 falls under immovable. Immovable and you cannot move them, right? Jewelry you can move, right? So when these 3 things are there, when you are using the option or ante idi leda adi rendu kaadu kada. So 3 options unnai, that is standing timber, growing crops and grass. So these 3 are included, so 3 is the right answer. I hope. Okay, so it does not include. Okay, sorry. The question is does not include, right? Yeah, so I'm really sorry. The question is, so these 3 things are actually not included in the immovable property. So even though you cannot move it, they are not included in immovable property for some reason. Yeah. Next, in India, the goods and service tax GST is based on the dual model of GST adopted in which country? So you know that we have adopted GST Act by enacting 101 Constitution Amendment. So which is the thing, right? We have borrowed it from which model? UK, Canada, USA or Japan? The answer is Canada, right? Next, 104, very important question. The Hague, Netherlands is headquarters of which international organization? Very good, Nayak. Very good, Uma. Hague, Netherlands is the headquarters of which international organization? I think we have to. Sorry, 15 instead of 20 minutes. Okay. What is your answer, guys? Well done. Very good, Uma. So International Criminal Court is headquartered in The Hague, Netherlands. I think this was discussed in GK also already. Right, very good, Nasia. So when it comes to World Health Organization, so World Health Organization is based out of Geneva, Switzerland. International Monetary Fund. Where is International Monetary Fund based out? It is based out of Washington DC, USA. And whereas Interpol, so Interpol is International Police. Okay, so this is based in the capital of France, that is Lyon, the capital of France. So Interpol is based out of this particular thing. Next, 105. Salaries and allowances of the judges of Supreme Court and the High Courts may be reduced by the President during the period of proclamation of సుప్రీం కోర్ట్ మరియు హైకోర్టుల న్యాయమూర్తుల జీతాలు మరియు అలవెన్స్లు వీటిని ప్రకటించే సమయంలో రాష్ట్రపతి తగ్గించవచ్చు. ఏ సమయంలో తగ్గించవచ్చు? వెరీ గుడ్ నాయక్, ఆల్ఫా, శ్రీకాంత్, ఎక్సలెంట్ గైస్. సో ద ఆన్సర్ is financial emergency. Financial emergency is imposed under Article 360 of the Indian Constitution. So when a financial emergency is imposed, it is imposed when the president feels that there is an imminent threat to the financial stability or credit of India. So at that particular time, he will impose financial emergency. Then the salaries and allowances of any class of employees that are serving the union and the states can be reduced. Any class includes sweeper or even the judge or president. Right? That is what. Now my question, which I asked you even in my class also. Now let us say I am working in Delhi. My salary is 1 crore rupees. Let us say I am drawing 1 crore rupees salary, and there is financial emergency. I am working in some private company. Let us say the name of the company is Thrinath Educational Services Private Limited. I am drawing 1 crore salary. Can President reduce my salary? Can President pass an order and reduce my salary and allowances? The answer is no, because I am not an employee of union government or state government. I am a private employee. So when I am a private employee, President has no power to issue an order, with respect to my salary. Next, 106. Which of the following is not a ground for divorce recognized under the Hindu personal law? Which of the following is not a ground? Sometimes when I am reading the question. హిందూ వ్యక్తిగత చట్టం కింద గుర్తింపబడిన విడాకులకు కింది వాటిలో ఏది కారణం కాదు. సో ద ఆన్సర్ ఈస్ ఇన్సాల్వెన్సీ. ఇన్సాల్వెన్సీ అంటే దివాలా. యు ఆర్ అనేబుల్ టు పే యువర్ డెట్స్ ప్రాపర్. That is not a ground. Adultery ante vivaheta sambandham. You are having some sexual relationship with somebody else. You can definitely, it's a ground for divorce. Cruelty of husband and relatives of husband, ground for divorce. Desertion ante you are leaving your husband or you are leaving your wife and you are going somewhere. You went somewhere, you became sadhu or sannyasi. So in that case also it is a ground for divorce. Right? Insolvency is not a ground for divorce. 107, last 107, 108, 104, last 3-4 questions. Which commission was appointed to investigate the circumstances that warranted the declaration of emergency in 1975? 1975లో ఎమర్జెన్సీని ప్రకటించాల్సిన పరిస్థితులను పరిశోధించడానికి ఏ కమిషన్ను నియమించారు? The answer is Shah Commission. So along with Shah Commission, you also have to remember Sarkaria Commission. So Sarkaria Commission is related to center-state relations, about which we will discuss in our class on important committees and commissions. Very good, Nidhi. Excellent. Well done. 108. Generally, an agreement without consideration is సాధారణంగా ప్రతిఫలం లేని ఒప్పందం. is what's the answer? Well done, Nidhi. Well done, Alpha. So the answer is void at a shunyam. It is completely not enforceable in a court of law. Like for example, if A is entering into an agreement to prepare to deliver 500 sweets, okay, to B. So this is the object, 500 sweets are object. The consideration has to be like 5,000 rupees, let us say. So ఈ కన్సిడరేషన్ లేనప్పుడు బి 5,000 రూపీస్ ఇవ్వాల్సిన అవసరం లేనప్పుడు అది అగ్రిమెంటేగా. సో ఏ బికి స్వీట్స్ ఇచ్చిండా ఇవ్వలేదా అనేది యూ కెనాట్ గో అండ్ క్వశ్చన్ ఇన్ ద కోర్ట్. బట్ when it is agreed that you will pay 5,000 and you did not pay, then only the agreement is valid. So if you are not making any consideration, it is not a agreement, it is not a contract, it is just a social agreement. Is it okay? It's just a gift, it is not a contract. Well done guys, well done, excellent. Alpha, Nidhi, Nazia. 109 dash is a right to keep possession of property belonging to another person until a debt owed by that person is discharged. Dash is a right. I'm not talking about what is it called. What is a right? Very good. So lien is a right to keep possession of property, right? So generally, for example, if you are pledging, this is I am A, I am B. A is taking A gave 1 lakh rupees to B. Now what B is doing? B is pledging his iPhone to A. When B is pledging his iPhone to A will have the right to keep the iPhone with him until B pays 1 lakh rupees. The right to keep this particular iPhone with him is known as the right to lien. Is this clear? Very good, very good. Nidhi and Uma, excellent guys. So charge is a charge, caveat is a notice or a warning, pledge is pledging the pledging part is giving your movable property, whereas possessing the movable property until the property is discharged, that is known as the right to lien, right of lien. Yeah, last question of the day. I want answers from everybody. Very easy question. The entry prevention of cruelty to animals is found under which list of 7th schedule to the Constitution of India? Everybody should answer. A very easy question, I would say. Well done, very good. Nidhi, Srikanth, Alpha. Very good guys, excellent. So the answer is concurrent list. So concurrent list is a list on which both state and central government can make laws. Animal prevention of cruelty to animals is a concurrent list. Very good Nazia, excellent. Okay. So I hope you guys have enjoyed this particular session and you got to learn something new at least from this particular session. If yes, please write a yes in the chat window. Very good Nayak, excellent. If you have enjoyed this particular session, please write a yes in the chat window and I'll announce tomorrow's session now. Okay. Very good Nidhi, very good Srikanth, very good Alpha. Well done guys. I hope you guys have enjoyed today's session. Tomorrow at 5:30 or 5 o'clock. At 5 o'clock I guess. Every day at 5 o'clock. Very good Nasir. Every day at 5 o'clock we will have a series which is known as Target 25 plus. Okay. So what is this Target 25 plus? Please pay very close attention over here. So Target 25 plus is a daily current affairs session wherein we will be aiming 25 plus marks in the current affairs section, for which I will be taking sessions almost every single day, like from Monday to Saturday. It will be like a 30 minutes to 1 hour session, okay, wherein every day we will be discussing some 30 to 40 questions from current affairs from August till May. August 2022 నుంచి May 2023 వరకు, అంటే మన ఎగ్జామ్కి అవసరమయ్యే కరెంట్ అఫైర్స్ అన్ని మనం ఎవ్రీడే 5 PM డిస్కస్ చేద్దాం. దాంతోపాటు 2 PM కి లీగల్ యాప్టిట్యూడ్ క్లాస్ విల్ కంటిన్యూ లైక్ దిస్, రైట్? సో at 2 PM the legal class will continue in the same way, and what is this, current affairs will happen at 5 PM. That's a fixed time every day. Okay, so guys, I hope you have enjoyed this particular session. Please don't forget to subscribe to this particular channel, and please hit the like button if you have enjoyed this particular session. please hit the like button, which motivates me to take another class tomorrow. Okay, so I'm looking forward to seeing you all in my next class tomorrow. If there are any doubts, feel free to reach out to me. I'll be more than happy to assist you. Okay, subscribe to the channel, and tomorrow I'll be coming up with current affairs chapter and also legal. Okay, Alpha, yes, you want to ask me something? I think no, I might have answered like most of the questions. Yes, please. Ask your question. I'll wait for you. For current affairs, can you tell us a month? It'll be a mix, Alpha. It'll be a mix. From every month, it'll be a mix. Tomorrow, we'll do it from, let us say, August. Go through August magazine. So we'll come up with questions from August. Right? Tomorrow, I'll take it as August. Just go with the August part. Okay, sure, no problem. Okay, guys. Hope you enjoyed this particular session. I'll see you all tomorrow at the same time. Legal will continue. Yeah, 5 o'clock I will take up current affairs class. Okay. Bye bye. Sure, Srikant. I'll share the link. I'll share the link.